Hello, dear viewers and subscribers. Today, please bear with me because I am not in a position to shoot and upload a video. And I also was down with viral fever for approximately 2 days and I have not yet fully recovered from it. Today, I'll be dealing with a question asked by our subscriber. His or her name, as appears in the comments, is VJ. So, VJ says, "Thank you for the information. Now, VJ is commenting below the video which is titled Admission Hearing Stage in High Court. So, VJ says, "Thank you for the information. Could you please distinguish between pre-admission stage and admission stage?" The second part of his or her question is also, "Is it true that a reply on affidavit as explained in this video is not required to be given by the respondent and he or she may argue it without such reply?" Sir, pre-admission stage really needs explanation. Kindly consider making a short video on it. Okay, so VJ and all my dear subscribers and viewers, let me first clarify that I have already made a video on admission hearing stage of the High Court or the Supreme Court and has uploaded it on this channel itself, explaining in it what exactly is admission hearing stage. So those of you who are interested in knowing the things in detail may please go to that video and watch it for full understanding of what admission hearing stage means. पर शॉर्ट में आपकी मेमोरी रिफ्रेश करने के लिए मैं बता दूं कि हाई कोर्ट में जो एडमिशन हियरिंग स्टेज होती है, द पर्पस ऑफ दैट स्टेज इज टू जस्ट scrutinize or screen the case with a view to find out whether the case really involves any such arguable point which needs detailed arguments, or the case is worthless and needs to be just dismissed at that stage itself. If the court, after hearing the parties at admission hearing stage, finds that the case does involve an arguable point, it is worth considering it in detail, then the court, High Court, in its discretion, admits the petition for final hearing, admits the case for final hearing. And then later on, the court conducts final hearing of the matter in great depth and detail and then delivers a final judgment. So broadly, there are two stages of hearing of any case in High Court: admission hearing stage and final hearing stage. Now, VJ's question is, what is pre-admission stage and what is admission hearing stage? तो मैं आपको बता दूं कि दोनों terms same ही है. Admission hearing stage itself is before admitting the matter, before the court actually passes an order admitting the matter, which is usually done by issuing rule. Now again, you might wonder what is rule and what is that, all these things. Another video is there, I have already uploaded, clarifying all these things, rule DC and all that. So just understand that admission hearing stage itself is conducted before actually admitting the matter. And that's why admission hearing stage itself is pre-admission stage. So don't get confused. There is nothing like a pre-admission hearing stage and an admission hearing stage like that. Both are same. Only the terminology that is used are different. Some people call it pre-admission stage. Some people continue to call it admission hearing stage. But the purpose is to hear the matter at admission stage. And that's all. तो इसमें कंफ्यूज होने की कोई बात नहीं है. आप ये दो टर्म्स में से कोई भी एक टर्म इस्तेमाल कर सकते हो और ध्यान में ये रखिए कि दोनों का मतलब है एडमिशन हियरिंग स्टेज. नाउ कमिंग टू द सेकंड पार्ट ऑफ योर क्वेश्चन, यू आर आस्किंग, इज इट ट्रू दैट a reply on affidavit is not required to be given by the respondent and he or she may argue it without such reply? Actually, the answer to this question can be given both ways. It could be yes and it could be no, both. Why I am saying this is because if the point involved in the petition is purely a legal point, in the sense that the point doesn't turn much on the factual aspect of the matter, as the factual aspects are already admitted, And the point that is arguable is only a legal point, a question of law, which can be answered on the basis of study of law, and by advancing oral arguments, then yes, there is no need to file reply. I mean, in spite of that, people do file replies, but a particular respondent may choose not to file a reply and still may choose to argue the case on that point of law just orally without filing a reply. That is quite possible. But this is possible, in my opinion, only when the case involves purely a question of law and not a question of fact. If, see, there is some aspect, some factual aspect of the matter in the petition which the respondent wants to deny or to refute or to resist, that cannot be done orally alone. For that, an affidavit in reply will be required to be filed. A mere oral denial of a factual aspect of the matter during oral hearing of the case before the High Court will not be permitted. And if the respondent insists upon that, the court will not treat that denial as a real denial. Because you see, the law of pleadings is very clear. Whenever the respondent maintains silence about any particular fact, that fact is to be presumed as admitted by the respondent. So court will proceed with that presumption, the presumption that the respondent agrees to that fact. But if you do not want the court to draw that kind of presumption in favor of petitioner and against the respondent, then the respondent will have to deny that on affidavit by filing a reply on affidavit. होता है ऐसे कई बार रिट पिटिशन में भी ऐसे क्वेश्चंस ऑफ फैक्ट्स अराइज होते हैं जो डिस्प्यूट करता है अदर साइड. और जैसे कि मैंने पहले कुछ वीडियोस में बताया, इफ द पिटिशन इन्वॉल्व्स डिस्प्यूटेड क्वेश्चंस ऑफ फैक्ट्स, द हाई कोर्ट्स आर रिलक्टेंट टू entertain the petition. High courts will dismiss the petition on that ground and relegate the parties to the civil court to decide those facts in the civil courts only. High court में writ petition तभी आगे जा सकता है जब facts pleaded by the parties, the petitioner, are established either on the basis of records or on the basis of admission of the other side. तो facts के बारे में अगर serious dispute करना हो, तो affidavit in reply will have to be filed. So, to sum up, the answer to your question is, a respondent may choose not to file affidavit in reply in case the point that is involved, the point on which the whole case turns, is purely a question of law, a purely legal question. But if some factual aspect is involved in the matter, if there is a contest on factual aspect of the matter, then the respondent should file, is expected to file and refute that factual aspect or deal with it in whatever manner it wants in affidavit in reply. So Vijay ji, I hope you got the reply to your question through this audio video. Thanks.